content carried in here is suitable for general family viewing.
And welcome once again to your favorite show on television, the only legal aid show that gives you information on matters of the law, educates you on things you need to know about laws that matter relating to everyday activities that you have to do in your day-to-day lives. Today, once again, we are coming to you straight from Kenyatta University School of Law, located here in Parklands in Nairobi. We are talking tenancy and the landlord, the law that decides what that relationship is going to be like. And we have brought in an expert to talk to us about that law. And we've done one better because we brought in a professor who will discuss with us this issue of tenancy and the landlord. Now, we are on Facebook and YouTube and Twitter. Make sure that you check us and send in your comments and questions regarding the topic of the day. Without further ado, I want to introduce my guest to you so that he can tell us his name and also his expertise in practicing. My name is Dr. Ngugi Kingara, and welcome, Prof.
Thank you very much. My name is Busalile Jack Mwimali. I'm an associate professor of law at Jomo Kenyatta University of Agriculture and Technology, but I'm currently on a leave of absence as the editor-CEO at the National Council for Law Reporting.
Okay. So what is law reporting about? I see that you have a very nice card here. This organization tells us about its profile, its activities and functions that you have to do to serve the public.
Thank you very much. National Council for Law Reporting, which is popularly known as Kenya Law, that's the brand name, is actually a parastatal. It is a statutory body that has been created under the National Council for Law Reporting Act of 1994. Its mandate is essentially to report cases that are decided by the courts of superior jurisdiction and the development of jurisprudence. We also have a mandate that has been delegated to us from the Attorney General's office. We do report on legislation, the laws that have been passed and enacted by Parliament. That mandate, of course, also includes laws that are now being created by the county assemblies. Okay. So we do report laws, including international law in that respect.
Okay, yes. Very interesting there. Now, and then your role as an advocate of the High Court of Kenya, how is that like for you?
Yes, I'm an advocate of the High Court of Kenya of 14 years standing. Okay. I have also been in legal academy. At least that's my primary endeavor, because I have been a lecturer for the last 15 or so years. And I was actually privileged for about 7 years to teach in this school. One of those things that I taught in this school is land law.
Ah, very, very good that you're coming back home. Like you're like one of one of the other guests that was talking about teaching here, which is a good experience.
Yes.
And you can see now we are on television. We are doing it live.
Yeah.
Okay. Now, tenant and landlord relationship. Is that your area of expertise?
It's part of my area of expertise. Actually, one of the areas that I taught is property law. Okay. And property law necessarily involves that relationship between a person and land as a peculiar aspect of property. Okay. Of course, it involves now ownership in absolute and ownership on term basis.
Yes.
And we'll talk about what that absolute and term basis
yes,
is like.
Indeed we will. And I think the best place to begin, I think we were having a bit of a conversation on where actually, when one is talking about the tenant-landlord relationship, where should one begin? And that, you informed me correctly, that the land in the word landlord is the place to begin, that concept within the law. So explain that.
Thank you very much. Actually, one must understand the notion of land to be able to understand where that landlord-tenancy relationship arises. And when you're talking about land, or the notion of land as property, is because of the peculiarity of land as a substance, unlike other movable property, because it has some elements that you would not find, say, in a movable property like a chair, where I can sell you and you go with it.
Yes.
In land, there's that essence of permanence, of it being fixed at a place, the cost being almost fixed. And in most cases, unlike other property, the value will always appreciate rather than depreciate. So it has a very peculiar special value. Now, from that conception, then you must understand that there are two relationships that one would have with land. There are those that are offered to the person. You come and I give you an accommodation in my property, which is intended to benefit you as an individual. The right that I've given you, in law we call it a right in personam, a personal right. Essentially, it implies if you move, then that right is extinguished. There are also rights in land that are rights in rem, in the property itself. So that even if you are to move, or God forbid you pass on,
yes,
that right is still transmissible because it attaches on the land rather than on the person. And that notion is what now creates the relationship between land and the owners of land. Now, to go further, in that land, there may be a duration of interest that you enjoy. So essentially, if you are an owner of land, the most common interest that you know is what we call a freehold estate, a freehold interest. It is for an unlimited duration. In England, they call it fee simple. So I have given you a land. I've not limited the duration in which you'll enjoy that land.
Right.
But it can also be a term of years. It is almost the same interest, but I have given you to enjoy for a term of years. That term of year does not necessarily mean it must be for a year, the 365 days. It can even be 3 days, 1 month, 1 year. You have encountered longer leases, 10 years, 55 years, and the most common 99. But you also encounter 999 years leases and even 3,000-year leases. What they confer to you, because it's a proprietary interest, it's an interest in rem, in the land.
Yes.
It subsists over the land for that duration of period. So any freehold owner, if you are owning that right in freehold, and a person is owning it in lease, you almost have the same interest. But for the leasee, he has the interest for the duration that he's been granted.
Yes.
Now, the only distinction that comes in, there is a further relationship that is created in a landlord and tenancy agreement.
Yes.
Because now there is an ownership that is conferred upon the tenant, but there is a reversionary interest on the landlord.
Yes.
So there is a kind of agreement between two people that I'll give you enjoyment in absolute over this parcel of land for 5 years, for 15 years, for 99 years. But after the expiry of that term, you must use that property in a manner that I should be able to come back and enjoy all rights that pertain to that property.
Okay. And now, what about, of course, people are thinking, well, we're not talking land law again, are we?
Yeah.
So, but you're trying to go step by step
into that
to even now go to a compartment or a place that sits on a piece of land, which is now where the tenant finds himself or herself.
And it's also important to understand the conception of land, because land is not necessarily the ground.
Yes.
It also includes everything that are annexed to that ground that are permanently there.
Yes.
So there are tests that are given in law which would determine whether something is part of land or not.
Yes.
So if you go to a house, that house, even without the land in which it stands on, is still considered as land.
Yeah, I live on the 5th floor. So
yes, in the 5th floor you have proprietary, you have land interest in the 5th floor apartment.
Okay. Yes. Now then, within the law, so who is a tenant by definition of this land-tenant relationship law?
A tenant is the person who goes to lease that property. The occupier who comes in to agree with the landlord that you will give me possession of your property and I'll occupy it. And at the outset, I want to also comment that the word landlord tenancy or lease are used interchangeably, so that it is a tenancy, it's a lease. Sometimes if you look at the documents that are signed for you by the advocates, you'll find terms like a demise or a determinable rent or a determinable lease. All of them means the same thing. So irrespective of whether I'm talking about a tenancy or a lease, we are talking about that landlord-tenancy relationship in respect of land.
And then the tenant, of course, is the person who has the place that lets.
Yes.
Okay, now what are the characteristics of the tenancies that exist that are within the law that you faced when you were in your practice?
Now, a tenancy by itself is not actually what you may call it by your agreement, but it is what the law determines to be a tenancy. Or to put it in another way, we may have an agreement between myself and you, and I offer you, permission. So I'm not saying I'm giving you a tenancy or I'm not giving you a lease, but I'm just allowing you to occupy my land.
Yes.
But if the characteristics or element of the grant that I've given you lead to the conclusion that that agreement is a tenancy, despite what we have written down, the law will take it as a tenancy. There are certain elements that would lead you to know whether it's a tenancy. Yes. One of it is that it confers upon you exclusive possession. Exclusive possession means you are absolutely allowed to occupy that place and to exclude every other person, including the landlord.
Yes.
So the landlord cannot come at the middle of the night and knock at your door and say, I want to have a place to sleep, this is my house. He has conferred upon you exclusive possession.
Okay. Another characteristic?
It must be for a determined area. There must be demarcation. As I have said, you see, you cannot have a tenancy or you cannot let out a place if you do not know exactly what it is. And then it must have a determined duration. We call it a term, a period within which it will subsist. And that is what distinguishes it from the freehold. Because I have said it is for a number of years. So it must be clear that it will start at a particular time and end at another time. Actually, I'll give an example of what happened during the Second World War in England and a case law to that effect.
Okay.
During the war period, people tended to give property and in lease, they let out these properties.
Yes.
And then they would agree that those leases would last for the duration of the war. And then they would agree on lower rent because of the war situation.
Right.
So at the termination of the war, people come to court and say, no, this was not a lease because it was not for a determined period. The duration of war, even though now it has come to an end, was not quite clear. The courts agreed that an agreement for the duration of the war is not a lease. But Parliament interjected to ensure that it saves that particular lease. So it said, and there was an act of Parliament, the War Act, indicating that all those leases that had been created for the duration of the war would be deemed as a year-to-year leasehold, but would end at the end of the war. So they are determinable. You can bring them to an end at the end of the war. So it saved that condition that it is still for a certain duration. So all leases must have certainty in duration. And before you interject, there is a last element which is a bit more controversial because of the requirement for rent. Okay. There is a case called Street versus Mountford. They said for it to be a lease, it must be it confers exclusive possession, which I have talked about. It must be for a duration that is certain, beginning and ending, and it must be for a rent. Because rent confers or brings upon that relationship the binding nature. You know, it now becomes a contract. And in law of contract, they say, if you have an agreement that is not, it does not have something which is a consideration for it. There's no price for that contract. Then that contract is not enforceable. So in that case, the supposition was that for there to be a contract between the landlord and tenant in a lease, there must be rent. But the law has come to nullify that requirement. And it is clear even in our Land Act, it says with or without rent, as long as it confers exclusive possession for a determined period of time.
In fact, my interjection would have been about the contract, meaning that therefore, depending on, actually based on what you had described, I said, then there must be a contract drawn. But the question is, from what, maybe a clarification from what you just said, it doesn't necessarily have to be a written paper contract. Is that true? So especially if there is rent.
Now, if you go back to the law of contract, there is a requirement for a contract, because we have said it's a property law, but it has an element of contract in it, in that the landlord and tenants agree. In the law of contract, for you to be able to enforce a contract, it is provided that it must be evidenced in writing, especially if it is relating to land. So essentially it has been said that any contract that confers a right or interest in land must be evidenced in writing. There must be a document, however the nature of that document, indicating that you have entered into. However, again, a challenge comes where we may not have written anything, but pursuant to the oral agreement, I have entered into possession. I'm already in occupation. You cannot just throw me out because we have not written something down. So there are certain interventions in a branch of law we call equity that comes in to try and protect that occupancy right. It recognizes that there is an interest between me and you that are equitable in nature, rather than the one by law which requires that we must have written it.
Okay. So then how does the law ensure that no one is taking advantage of the other, tenant and landlord, vice versa?
So there are what we call rights of tenants and rights of landlords. These are called tenancy covenants, or covenants in land, in tenancies. Now, the covenants principally are by the agreement in the contract itself. So a landlord and a tenant would do well, and that is why you normally go to lawyers, they draft for those contracts, because they would ensure that there are those particular clauses that are required to be in a list that are incorporated. But that notwithstanding, there are also provisions of law. Since I've said a lease is not determined by just what the people have agreed, but what the law considers to be an agreement. There are certain rights, certain duties and obligations. And of course, when I talk about rights and duties and obligation, it means if it is the right of the tenant, it's the duty of the landlord. If it is the right of the landlord, it's the duty of the tenant. The tenant.
Yes, I think we will capture some of that in the second segment as we discuss more on these matters of landlord and tenant. That relationship is an emotive issue, as you know, especially when one is told you have to leave. You know, it's usually like that. Stay tuned. We are still live, coming to you straight from Kenyatta University School of Law, and we're talking law matters, landlord-tenant relationship. Catch us on our social media platforms. Send in your questions and comments on things you would like to talk to us about in the final segment. Stay tuned.
We're going to be doing an Italian dish, which is none other than chicken piccata, served together with Italian pasta, together with a mix of African creamy vegetables.
Today we are going to talk about line following robot.
This project we started like 2 years ago.
We have been doing it for 2 years. You know, for us, we deal with software more than hardware.
And generally what I do is I major in the hardware part of it, the connectivity, the body, how everything works.
Arduino board, we have it control, it has different wires that comes in and that gets out. We have the power, we have the ground, all those. Then here we have the wires that connect between the board, that is an Arduino board, and also connect it to the motor controller.
Lola ni programu inayokupa fursa ya kutizama video zozote pindi tu unapokuwa na nafasi. Hadithi za kukupa motisha, drama, maisha ya vyuo vikuu, teknolojia, masuala ya jamii, kuzuru maeneo tofauti, spoti, burudani na zaidi. Pata programu ya Lola sasa kwenye rununu yako kwa yote unayohitaji.
Welcome back to our second segment of Law Matters. Episode is landlord-tenant relationship. And as you know, Kenyatta University School of Law and KUTV are in the business of doing community service. And we're doing this legal aid clinic on television. And today we have brought in an expert, Professor Muimali, to talk to us about the landlord-tenant relationship, which we know is an emotive topic. And all of us are waiting to hear and get more information on how to deal with our tenants or our landlords. We were talking about rights, and we left it at the rights of a tenant.
Yes. Now, when we talk about the rights, we should also emphasize that there are rights that are conferred by the law itself. Mm-hmm. And there are those that are agreed by the parties. There's nothing that prevents you from agreeing on certain rights and obligations.
Yes.
So I may say in a document, in a contract on lease, that you will be the one who will do.
Get something in the back there going on. I think they will take care of that. They will take care of that. Yes, so we were talking about guaranteed rights by law.
Yes.
And those
that are contractual.
The tenant and landlord agree on.
Yes.
Yes.
And those contractual ones, for example, you can agree who will repair.
Yes.
If there are defects. So there's nothing that prevents you from saying, even though I'm the one occupying the house, the landlord will do all repairs.
Okay.
There's nothing that prevents you from agreeing that the tenant will do those repairs. It is contractual on you. Or there is an agreement on who will pay the service charges and all accruals. Supposing there is a destruction, who will be responsible for reconstruction and all those. So those are contractuals. But most critically, perhaps, is to talk about those rights that the law confers. So that irrespective of what the parties have agreed, the law actually confers that interest on the landlord and tenant.
Okay.
Now, for the tenant, there is the first and most critical right, which we call the right of quiet enjoyment. That when I confer you with a property, I should not interfere with your enjoyment of that property. It is for that duration of time, you are the absolute owner of that property, and therefore you should be able to quietly, without interference, enjoy that property. And there have been a number of cases which have been held to constitute derogation from that right of quiet enjoyment. So for example, a landlord comes every day and knocks at the door. He sends people to interfere with your possession. You know, he sends his animal to feed around your compound and all that. All of them have been deemed to be going against that right of quiet enjoyment. That you, as an owner of that property, you can exclude even your landlord who assures or guarantees you that you will enjoy that quiet possession. But secondly, there is also a related right called non-derogation from the grant.
What's that?
I've given you a facility for you to use it as a kiosk. It necessarily implies that I must facilitate the business in that premises for having a kiosk. Supposing I come and close the entrance, so that people cannot come in.
Yes.
You see, I'm derogating from the grant because we knew from the outset that I was to use that facility as a hotel or a shop.
Yes.
So there is also that right, that which is the tenant's right and obligation of the landlord, that he shall not derogate from the ground.
Yes.
And I think those are the critical things that we encounter in our day-to-day landlord-tenancy agreement. So a landlord comes and says, I want to do this tomorrow or Saturday. If he must, he then ought to give you sufficient notice. Otherwise, he may be found to be derogating from the grant.
Yes.
And then, of course, there are others that if I'm letting it out for habitation or occupation, I know I'm giving you as a house which is furnished apartments, then I must guarantee that they are suitable for habitation.
Habitation.
Yes.
There's one that people probably are waiting to hear about, which might be thought of as a right of the tenant to do, which is increment of rent.
Now, that may be considered the right of the landlord, but the tenant is again protected from absolute and haphazard increment of rent.
Yes.
Of course, in the first instance, and for most tenancies, the law does not want to interfere with your freedom of contracting of agreement. And therefore, it will not engage with you because you have agreed that I'll pay 100,000 for this small apartment, and now I feel it's too small for 100,000, I want 50. Or if the landlord wants a bit more, and you agreed that he can increase, the law will not include. It only comes in when there are unconscionable transaction, where they can actually see this person is taking advantage of the other. And normally that is not done in all kinds of tenancies. There are certain tenancies or leases that we call protected tenancies. Like for accommodations that the rent, when they made that law in 1989, was that it should not be in excess of 2,500. What you would pay in 1989, 2,500, perhaps now is going for 20 or 30. And that's what the courts have held. So for those tenancies, they cannot add rent without consulting the tenant or even going to the court for court to agree on what rent can be imposed. They cannot also evict you without giving you sufficient notice or going to court to have the court now order that eviction. So there is a kind of intervention. Similarly, you will find the same protection, a protected tenancy in business premises, where now you won't go to the courts, you would go to the business premises tribunal, which will give you certain remedies that are easier to find than when you go to the normal ordinary courts.
And the deposit, I mean, this is also another issue. What should I get my deposit in full towards the end, or should I even get, I always asked, should I get it in interest? Because you've held my money for 10 years and here I am trying to leave and you're saying, oh, by the way, nitakata.
Now, there are two things. Deposit is an issue of contract because there is no way, there is no place in the law of tenancy where a deposit has been mentioned. It is a practice that people agree that for me to safeguard my reversionary interest, after your duration is ended, I'll have to come back to my house. There may be things that may have occurred in that house that I may need to replace. So it's a kind of a safeguard or security that the landlord gets in order to be able to ensure that by the time you leave, he will be able to get the property in almost a similar condition that it would have been, not at the time of grant, but if he had used it himself and it had used it well, with all the depreciation, it would be at that condition. So you see, we have sometimes small children. I remember one of my children actually went and drew in the wall. So when I'm leaving that house, you see, I cannot just leave it with those caricatures that have been drawn. The deposit is supposed to facilitate those kind of arrangement. However, if you have done all that and you are leaving the property in the same way it would have been had it been used by the owner. So it's not how you found it. You see, there is that element of depreciation. After staying in a house for 3 years, it will not be as good as new. It will be as a property would be after 3 years.
After use.
So if you are at that position, then you are entitled to receive your deposit back. But most of that is actually an element of contract that the law itself does not stipulate for.
So now for these cases where now we have a controversy or an issue with each other, my landlord, the law has its conviction terms that it throws at the landlord.
Yes.
Well, how are they determined, and what is the range between the number of years, if it's years or fines that they're slapped with?
Normally, when you're talking about landlord-tenancy agreement, there are hardly penal provisions because this is a civil issue.
Yes.
It's a matter of civil law, and therefore it doesn't revolve around one being punished.
Yes.
Of course, there are a number of penal provisions that can be made.
Yes.
So that if a landlord goes against certain, like for example, if you evict against a court order, then they can, the Act can provide for some level of penalty to to prevent you from that kind of behavior or conduct.
Yes.
But by and large, when we look at landlord-tenancy relationship, we should not be looking at the punishment. It gives civil remedies. For example, the landlord can evict you. You as a tenant, if there is a derogation, you can refuse to pay rent, withhold that rent. It's about the civil relationship that you have, not a criminal nature of interaction.
So your advice here is for us, the tenants or landlords for that matter, not to rush to court to settle some of our disputes?
No, there are courts that deal with civil matters. But depending on the nature of your tenancy, you need to be able to choose the right forum. Because even for a landlord, you may have a tenant who has been staying in your accommodation for 5-10 years, they don't want to pay, or they pay very little. You also entitled to that remedy. Go to the tribunal, tell them this is the value of the property, this is what was being paid, and I want the court to reassess what is reasonable rent so that they don't take advantage of me. So it's a balancing act. It's not just leaning on the side of the tenant.
Yes.
Of course, the relationship between the landlord and tenant, by its very nature, favors the landlord because he's in a position of authority. He can easily throw you out and remain with that property. And therefore, the law tends to protect that weaker side. And you'll see the remedies that it accords to the tenant in more cases are more forceful than the one that it accords the landlord, because the landlord's rights can include re-entry, taking back that property and throwing you out. He can even distress, come and take some of your properties and sell them in order to recover that. And also the civil claim, he can just go and make a claim that I have not been paid 100,000 and I want a court order, and then you enforce it as any civil court order.
Okay, and then occurrence of dispute has happened. What's the time limit between going to court and when it expires? After this point, you can't come back and say, oh, he lived in my house for 20 years and I didn't come to court for 20 years because now I'm here though.
Normally the law does stipulate for a limitation of action, where they say there are certain periods, if it goes beyond, then you would have slept on your right, and then you cannot now come to court and tell us that you want us to afford. It will be leaving room for litigation in perpetuity, and the law does not also want to encourage that. So ideally, for matters relating to contracts, and I have said the lease, though a proprietary interest, relates to contract. If it is a contractual element, you have to bring a suit within 6 years. But there is also the issue of possibility, if it only relates exclusively to the land, you have not done anything, you have allowed me to stay in your land, then after 12 years, I can get what is referred to as prescriptive right.
Meaning?
On adverse possession. It means I am able to now claim that an interest in that parcel has accrued to me, and I can even go for registration so that I be registered as the owner, because it means for those 12 years this person has never thought to evict or remove you, and therefore they should not be allowed after 12-13 years.
So in your assessment, how effective is this landlord tenant relationship law in our country, according to your experience and
the challenge by and large is because it entirely and strongly relies on the contract. Even though the law intervenes,
yes,
it intervenes in a very limited sense by those rights that it confers upon you. It is only prudent for you as a landlord or for you and as a tenant to ensure that you enter into an agreement that is more watertight. And in all countries of the world, the law does not want to prevent the freedom of people to agree on what they want. So even in Kenya,
yes,
that is a position. Unfortunately, you know, in Kenya, there are not many people who have that wherewithal of being able to enter into very solid and concrete agreement. You want a house to rent for 10 years because you're working here, and you want to pay 20,000. If you want to see me as a lawyer to draft a very solid agreement for you, then you should also be able to part with another 20, 50,000. So it becomes too expensive. And those are the challenges that we encounter in the relationships in Kenya. So that is why one may want to suggest that perhaps against that backdrop, the law should be a bit watertight to consider issues that are particular to this country and not just use the contractual freedom of people to allow them to do as they wish.
Then your advisement is what in terms of tenants and landlords, for that matter, protecting themselves from future dispute, or what you would call prospective disputes, because they are engaging in flawed contractual relationships that will lead to dispute anyway.
My first advice is for you to get reasonable protection. First of all, evidence those agreements in writing.
Okay.
It doesn't have to be a complex contract, but just an agreement. I've gone up country and I've seen those transactions that our fathers used to enter into. Some of them could not even write, so they go to the chief and you see so-and-so was present and he signed so-and-so was present, and then they say, this elder has sold so much, and the chief signs and the elders put a thumbprint. At least there is a document that you can use to enforce your rights. So it is critical, as per the law of contract, that you must evidence it in writing. Secondly, you also need, if possible, and if you are able, to ensure that you understand the nature and form of agreement that you are entering into. Because you may be entering into a license. It's just a mere permission. And that license can be contractual. It does not revolve or attach on the land, but it's a personal interest, and therefore the landlord can terminate it as he would any other contract without proprietary protection. So you need to be able to ensure that you safeguard that right and interest in that sense, that you understand. And that is why sometimes, even though expensive, it would only be reasonable for you to consult a lawyer. You may pay an extra amount, but that keen eye to see that there's these clauses that may go against you, and for that long period of time, you are almost going to lose, then that would be, it's a small price to pay, so to say.
Okay. Yeah, you've mentioned license there, and in terms of occupancy of a place. Can you elaborate on, because I know you and I were trying to, you trying to tell me about the distinction between that and, you know, real tenancy. License in occupation, so that people get to know. And because I have a question regarding that after you explain that.
Yes. Now, a license is normally a personal right that is conferred, the right in personam, rather than the proprietary interest that is conferred. So if the interest belongs to you, it is a license. It's a right, a personal right. In personam means in your personal. A right in rem means a right in the substance, in the property itself. So anytime you may have a relationship that seems like a lease, but it does not meet those pre-qualifications. It doesn't confer you exclusive possession for a determinate time. It is not, then that would not be a lease. It would instead be a license, which means it's a personal right. Now, with the personal right, it is easier to terminate than with the proprietary right, because a proprietary right runs with the land. So even if I die, my family can still claim my interest because that interest attaches on the land, not to me as an individual.
So I'm hearing that if I went to a hotel and book a room and I'm told you must leave at 10 a.m.
Yes.
I can't pretend I paid.
Even though, you see, and you can even stay in that hotel for a year.
Yes.
Paying rent, but they'll be giving you certain attendances. It means you will be leaving your keys, they'll be coming and cleaning that place, they'll be making your bed, they'll be doing supplies, and therefore you have no exclusive possession.
Yes.
So that element that we talked about, exclusive possession, is lacking. But you can also go to the same hotel, but you are given your key where you lock, you do your cleaning, you do your everything there. Then that becomes a lease. So
Okay.
it is the relationship, it's not what you have agreed upon, it is what the law perceives to exist. They look at the conditions, that does it meet the conditions for a tenancy. If it is not a tenancy, it's a license.
Then one final one before we go on break. There is an intermediary sometimes who is called an agent.
Yes.
You know, you go to this person and they find a house for you, and then they are actually the people who bring the contract to
Yes.
you. What does the law say about how they operate?
That brings out another legal relationship where a third party, now called an agent. An agent is just a person who works or does something for another person. So I don't at every time have to do it personally. I can task you with going to do it for me.
Yes.
And the law that is applicable there is the law of agency. So whatever the agent does, if it is within the authority that he was granted, then it is as if the principal, the person who sent him himself, did. So agency just shortens that processes. You don't want to be running to collect rent, to follow. So you send somebody who is in that business to be your agent, so that whatever you would have done in that agency agreement, you say you will do it for me. So if I was able to enter into a contract with the tenant, I give you that power to enter into that contract on my behalf.
Very interesting. I think we are all very well informed now in those matters of tenancy and landlord relationship. Stay tuned and keep interacting with us on our social media platforms at KUTV Kenya Live on YouTube, at KUTV Kenya on Facebook, and at KUTV_Kenya on Twitter. We'll be right back with responses to your questions and also comments that you may have. Stay tuned.
We're going to be doing an Italian dish, which is none other than chicken piccata, served together with Italian pasta, together with a mix of African creamy vegetables.
Today we are going to talk about line following robot.
This project we started like 2 years ago. We have been doing it for 2 years. You know, for us, we deal with software more than hardware.
And generally what I do is I measure in the hardware part of it, the connectivity, the body, how everything works.
Arduino board we have, it has different wires that comes in and that gets out. We have the power, we have the ground, all those. Then here we have the wires that connect between the board, that is an Arduino board, and also connect it to the motor controller.
I'm running a company that is lending to people. How did I do that? Integrity. The people you're working with here today are the people that will support you when you finally decide to do something.
What's the weirdest dream you've ever had?
Weirdest dream. Weirdest dream. Oh my God.
And what should you say is your general experience working at the bank?
Working in the bank gives you a really good background to whatever kind of thing you want to do in the future.
Welcome back to our third and final segment. We are still here with Professor Mwimali talking about the landlord-tenant relationship, and he has informed us and educated us on many matters. So this is the segment where we get to answer your questions, and as it's our tradition, we start with our studio audience and questions they may have. Can I get the first question, please? Right there in the back.
Okay, thank you. My question to Prof will be, because you have referred to tribunals severally, I would like that you expound for the members of the public what these tribunals do, maybe where they sit, and perhaps what is the process of approaching these tribunals. Thank you.
So the tribunals for settling these landlord-tenant disputes?
Now, for those relationship, there are two tribunals. There's what we call the Rent Restriction Tribunal. There's one in Nairobi, and I know they are in other places. I think the one in Nairobi is around the CBD, but in most cases, practitioners would know exactly where the tribunal is. Now, the Rent Restriction Tribunal actually just deals with residential tenancies over limited rents. So we are not talking about where you are paying 50, 100,000.
Yes.
I mentioned earlier that when that act was enacted in 1989, they said that it is for rents that do not exceed 2,500. Of course, that was reasonably high. Though with that kind of rent, you would stay in Makadara, in Huruma, in Jericho. So most of those houses. So the court has equated, because that act has not been changed, that what was 2,500 then should be the equivalent of what now they can determine. So they have determined matters where the rent is about 20, 25, but not very high rents. Now, it is supposed to help these people with low rent agreements to, instead of going to the formal civil courts, to go to a body that is quasi-judicial. It's not entirely judicial, and therefore it doesn't rigidly follow procedure. So you can even represent yourself. Just make your documents. These are plains, and in most cases, there are people who can help you to just make those pleadings and submit it to the Rent Restriction Tribunal without necessarily needing a lawyer to represent you. You can also have a lawyer, but even the people who sit and pretend over that tribunal are not exclusively lawyers. Of course, the chair of the tribunal must be a lawyer, but they can be non-lawyers, those persons who are some experience outside law related to these issues that would sit there. So you are able to go to those tribunals to determine what is fair rent, for example, to prevent eviction, to also allow for eviction. So you can go whether as a landlord or a tenant to determine those issues, and it is a little bit better. The second tribunal is the Business Premises Tribunal. Again, the Act provides for a framework for business tribunals, for business premises, for durations of about 5 years. So they don't want you to come into an accommodation, have your business run so well, and then after 2 years, you've developed your goodwill, and then the landlord tells you, no, you have to move out of this building, so that he can either give it at a higher rent because of the goodwill that you have developed, or even himself run that business because already he has customers. So it protects those tenancies, and that is why we call them protected tenancy. You don't have to go to court. You can go to these tribunals. The processes are much more flexible than the ones that you employ, and they take lesser time.
Okay, very informative. Now, another question?
My question will be about lease. So what happens with these companies like Ngugi, Del Monte that take maybe a 99-year period lease and then it expires, do they have a chance to renew it, or what happens after that, considering they are huge companies?
Actually, that's a very good question. A lease is for a duration. After the expiry of that duration, then the owner, the landlord, is entitled to have it. Now, when you talk about entities like Ngugi, the leases they have has a public element to it, in that the grants have been given out of public land. In as much as they have been given as a private lease, it's on public land. So there are certain elements or level of protection. For public land, in most cases, there is a right that is conferred on a tenant at the expiry of that leasehold. If the government doesn't need that property urgently, there's a right called the right of preemption. You will be given the first opportunity to renew that lease unless the government requires it. It's only when you don't show any interest. Because you see a 99-year lease, like the ones in River Road and Grogan, you would have built a house there. You know, the rates and the value that you have at that property is too high for them to just, after 99 years. And some of those leases in Grogan and River Road were given in 2020 under the Crown Land Ordinance to the Wazungus, because that was CBD for 99 years. So 2020, they expired in 2019. Some were given in 2015. They expired in 2014. And you remember that time there were a lot of issues at the Ministry of Land because most of those leases that were conferred were expiring. But to answer your question in short, you have a right of preemption. If it's a private lease between me and you, of course, there is no compulsion in that element because there is no element of public law intervening. So you cannot force me to renew a lease just because it has expired. But for government leases, then there is that element of the right of preemption that is afforded to the tenant, that you will be given the first opportunity to renew that lease before it can be offered to anybody else, or unless the government needs that property now for public utility.
Okay, now there's an online one here from Brian Kirui. It might sound silly, but maybe it's true. So he's asking, is it true that when a landlord wants to evacuate a tenant, that a tenant will be given at least 3 months to stay without paying rent? Why would someone think that way?
No. Because actually in an agreement, at the end of it, it is the landlord's right to also receive the rent. We talked about the tenant's rights. One of the landlord's core rights is the right to demand and receive rent. And if you don't pay, he has even the right to repossess, the right of re-entry.
Yes.
So anytime you enter into an agreement, then you are bound by that agreement in that sense. You have no right to continue to stay without paying rent. I know perhaps his view emerges from the fact that in many cases, a landlord would require you to pay 3 months deposit, and then it becomes very difficult for them to give back the deposit. So you in lieu of receiving back that deposit, you want to stay for that period of time. But remember, there's the other element I talked about, which you may then be required to do some renovations to leave that house in a condition that it would have been if it had been used appropriately. So you may have to do the painting yourself, but sometimes then you would leave the deposit with the landlord so that he would use it for those repairs. So those are some of the considerations that you want to make. Some think that I'd rather paint because, you see, I will not have to paint it as if it was new. I'll just paint it to put it in a condition. If you have occupied for 5 years and it was a new house when you occupied it, I want to leave it how a 5-year-old house would be. So you don't have to use so much money. But if it's the landlord, they would want to do, to make it as good as new for the next tenant who is coming in.
Okay, sorry, Brian, you still have to pay some of your rent money. Final question?
Yes, so I have a question to Prof, and I'll ask it in 2 folds. So the first fold, now that the country is still recovering from the COVID-19, did the COVID-19 in any way affect the law on tenancy, more so the relationship between the tenant and the landlord? Then the latter fold of my question is, now that people who are rendered jobless overnight, is there any room whatsoever for a tenant to be exempted from paying rent? Thank you.
In the first instance, perhaps the answer is no, and there was a move by many people to have government intervene because of the challenge that many people faced during that period. And of course, the government also asked or requested in the form of an order. You know, the government orders even if it is requested. So it requested landlords not to increase their rent. Of course, that is a request that the landlord can work on or can refuse to work on. There are, of course, some incentives that the government would give to try and allay that problem, so that it says if, as a landlord, you allow your tenants to stay for the duration with reduced rent, or you have allowed them to stay without rent, then they will give you rebates on the tax that is payable on rental income. And therefore you have a benefit, and they can say they will reduce that for 5 years and all that. And that was the debate that was being had, that the government should intervene. It can't compel, because these are private relationship, unless it's a public housing project where it is the government itself that owns it. Then it can, by policy, remove that requirement for payment of rent. Having said that, sometimes it is also in the interest of the landlord, because yes, these are good tenants, you have had him for 10, 15 years, they have been paying, and you understand that because of COVID their business went aground. Would you want to have another tenant that you don't know whether they would be paying promptly as this old one, or would you rather have him and then have an arrangement that for these 2 years I can reduce your rent, and then when things stabilize, you can now go back and revert to the payment.
It's a case of mutual benefits,
yes,
and recognizing what each one got from the other before COVID, is it?
And there are quite a number of accommodations in town where, like, people because of COVID left and they have no occupancy. So if you follow up on rent to the extent that that tenant cannot come back, then you lose out also.
Okay, there's a short one here, very quickly, from Adon J. Kavagi, and he is talking about, after how long is the landlord entitled to evacuate a tenant who has defaulted rent payment?
What the law requires is reasonable notice to be given to the tenant before they can be evicted. So eviction is on the basis of reasonable notice. Now the question would be, what would constitute reasonable notice? Basically, the courts would look at the kind of arrangement that you have. For example, if it is a month to month, then at the end of the month you have not paid, the landlord can give you notice to pay and leave. Now, of course, what would be reasonable? Then maybe a month. Because it's a month to month. There are those arrangements where you pay in a quarterly, half a year, or an annual basis. Then the reasonableness of the period would be much higher. So it depends on the facts and circumstances of each case and how we would convince the court.
Yeah, well said. And also the contract and the relationship one has with the landlord, I think that counts for much. I think we cannot exhaust this landlord-tenant relationship law, and we'll have to leave it there. Maybe perhaps another day we'll come back with part 2 of the topic. But with that, we want to bid you goodbye. But we cannot do that without thanking people who made this show possible. Our studio audience, who are always vibrant with questions that keep us on the toes of our minds. And for our funders who make this show possible. For the Kenyatta University School of Law and the Legal Aid Clinic, thank you very much. Stay tuned next Tuesday when we handle another topic on law matters. Goodbye.